I think we have learnt a lesson in this regard. And in the past, emotions have been much more high, and our democracy has been much more volatile. And we did cave into the temptation during a democratic rule in 2015 through the 21st Amendment. And at that time, the reason given were that those who we are aiming to bring in the fold of or jurisdiction of the military courts are hardened terrorists, and because of the current situation of the country as it was then, there was legitimate fears and apprehension amongst the judiciary and amongst members of the bar vis-a-vis their own safety, and it was thought or deemed that regardless of whatever may be done in the short term, efficient and effective trials would not be able to be conducted. And begrudgingly, I believe the Supreme Court allowed this, and it was to be a purpose for a period of 2 years, and then its tenure was extended. But the trials which were held of those hardened terrorists, as we are told, in the military courts, the details of which were revealed in the judgment of the Peshawar High Court by the late Chief Justice Waqar Seth, as he examined that almost every single conviction had been secured primarily, or rather in some cases solely, on a confessional statement of the accused. And in almost every case, the statement and the format and the drafting of the confessional statement was identical. And many legitimate questions were raised. Because see, what we need to realize that after the 18th Amendment and Article 10A, which guarantees a right to a fair trial, we have to now proactively aim to secure the rights of any accused in court, and we have to jealously guard his or her democratic and constitutional freedoms. And there has been in the past, before this article was introduced in the Constitution, a Supreme Court held a view in 1975 in the case of Brigadier FBLE, which is cited as the precedent which allows for civilians to be tried in military courts. At that time, it was under the amendment introduced by dictator Ayub Khan in the year 1967 through an ordinance, whereby it brought in within the jurisdiction of military courts those civilians who had committed any offense under the Official Secrets Act 1923, or who were accused of seducing or attempting to seduce military officers to be disobedient and disregard their orders. Now, the Official Secrets Act, the name is very misleading. One would feel that this is an act which, tries one for the offense of espionage, or so if somebody is caught spying on national security secrets. But the ambit of the Official Secrets Act is very wide. It makes it an offense for anybody to take any picture within a notified area, and that could be, for that matter, every single square foot of the GHQ, even though the intention of taking that image is never to share or even share for the purpose of espionage, and it may be recorded for any other reason, but it is an offense. And if anybody retains such image to throw is being transmitted to you by somebody else, that is also an offense. If somebody impedes in the deliverance of service of any military officer, so for example, if you are arguing at the gates of the Corps Commander House or of the GHQ with the security guards over there and resisting their orders and not moving back and attempting to open the gate, you would very well be deemed to have committed an offense under this act. Then there is also the offense of incitement, that if you are present there, or your presence could be deemed as evidence of incitement, your mere presence, as these laws are very interpreted not in the fairest manners. So if you've been inciting anybody to take a picture or retain a picture or interfere or impede in the performance of service by a military officer or a law enforcement agency officer over there, you'll be deemed to have committed an offense. So these offences were added in the 1967 ordinance by Ayub Khan, and a case under this law of a retired military officer who was deemed a civilian, Brigadier FBLE, went all the way to the Supreme Court, and the Supreme Court said that what is a law but instructions given by an authority and which can be enforced by a court. And it said that the law doesn't have to be good or moral in order to be considered a law. Now, that was a interpretation of the Supreme Court, or the view of the Supreme Court in 1975. After Article 10A, I believe the Supreme Court, if it is to review the vires of these provisions of the 1967 ordinance, I believe they would have a much different view, and the Bar Councils of Pakistan should consider, in all seriousness, filing multiple petitions before the Honorable Supreme Court or the respective High Courts to challenge the vires of these provisions now under the 1973 Constitution as it stands today.